Welcome back, dear students. In the paper of drafting, pleading, and convincing, we are near to the close of Unit 4. Today, we will cover lecture number 37 in Unit 4, and we will learn how to draft a deed of arbitration. In the last lecture, that is lecture number 36, we have learned how to draft a reference to arbitration. When a matter is to be referred to arbitrator, reference to arbitration is also drafted, which we have already learned. Today we will learn how to draft an arbitration deed or deed of arbitration. The reference books which are available in our library of the college. First of all, we have a very good book written by Mr. R.N. Chaturvedi. Its heading of the book is Conveyancing. This book was published by Eastern Book Company in 2011. Seventh edition of the book was published. Then we have another very good book written by Mr. G.C. Munga with the heading Law of Pleadings in India. Its 18th edition was published in 2013. Then we have another book written by Mr. C.R. Datta and M.N. Das. The heading of the book is Forms and Precedents of Conveyancing. This book was published by Eastern Law House, 2008. 13th edition was published in 2008. Then we have another good book written by Mr. K.K. Shrivastava. The heading of the book, name of the book is The Law of Pleadings, Drafting and Conveyancing. This book was published by Central Law Agency in 1982 when its second edition was published. Then we have another book in our library written by Mr. S.R. Maineni. The name of the book is Drafting, Pleading and Conveyancing. This book was published by Asia Law House and its reprint edition was taken out in 2017. Now, before we start learning how to draft an arbitration deed, let me remind you, when we drafted a reference for arbitration, that arbitration is an alternative dispute resolution mechanism where the parties want that their dispute should be settled by mediation of a third person known as arbitrator. They do not want to go to the court because it takes a lot of time for the court to decide the matter. And dear students, even if somebody has filed a suit for redressal of their grievances, even during pendency of the suit, the matter can be decided by arbitrators. Parties will have to move an application before the civil court along with arbitration deed that the parties have agreed to resolve their dispute through intervention of arbitrators. As you know, dear students, whenever you go for arbitration, Arbitration and Conciliation Act of 1996 is applicable so far as the arbitration proceedings are concerned. Before 1996, we had an old Arbitration Act of 1940. That old act has been repealed by this new act of 1996. And there are two major changes in the new act. Number one, the intervention of the court is minimized now. Rather, courts have no intervention when a matter is decided by the arbitrator or by the panel of arbitrators. The intervention of the court is minimum now. And second important change is that award given by the arbitrators is not to be filed in the court. Under the old act, it was compulsory for the arbitrators to file their award in the court, and then objections from both the parties were invited, and then court used to decide the legality of the award. Now this provision of filing of the award in the court has been abolished in this new Arbitration and Conciliation Act of 1996. There is no need of filing the award in the court. The award is binding on the court, on the parties, without filing it in the court. Now, so far as the enforcement of the award is concerned, the award can be enforced like a decree of a civil court under Order 21 of CPC by moving an execution application supported by the award given by the arbitrators. And dear students, so far as the number of arbitrators is concerned, if parties have not appointed any arbitrator at their own, or number of arbitrators are not fixed by the parties, then arbitration shall be done by the sole arbitrator to be appointed with the consent of both the parties. Normally, one party appoints one arbitrator and another party also appoints another arbitrator. So in such a situation where the number of arbitrators is even, both the arbitrators are empowered by the new act to appoint a third arbitrator whose position is equivalent to umpire in the old Arbitration Act of 1940. But dear students, you must note, because you are going to draft a deed of arbitration, that number of arbitrators should be odd. It should not be even number. Even number means a figure which is divisible by 2, like 2, 4, 6, 8, 10. So a number of arbitrators should be in the odd numbering, like 1, sole arbitrator, 3, 5, 7. They are not divisible by 2. So the thumb rule is that number of arbitrators should be odd. If one party each has decided, has appointed one arbitrator and the number is even, then those two arbitrators are authorized to appoint a third arbitrator. He takes the position of sort of principal arbitrator or presiding arbitrator, and his opinion prevails because now there is odd number. And dear students, another thumb rule is that if the number of arbitrators appointed is odd, like 3, 5, or 7, then decision of majority or decision of all will prevail. Decision of all means when there is a unanimous award given by all the arbitrators. And if there is no unanimity between the parties, between the arbitrators, in that condition, the majority opinion will prevail. So with this background in mind, my dear students, now let us start learning how to draft an arbitration deed. So your question says draft an arbitration deed. So its heading should be arbitration deed or deed of arbitration. This should be the heading of your deed. Now, first of all, the date of agreement is important. You must keep in mind as to the date when the deed of arbitration was drafted. So in the present illustration, the deed or the agreement was made on first day of January 2017. So this deed of agreement is made on first day of January 2017 between. Now you will have to mention the name of all the parties. Parties may be two, more than two, but the minimum number of parties required for an agreement, as you know, is two. So here we have two parties. Number one, A son of B, resident of flat number 906, Designer Spark, Sector 62 Noida, District Gautam Buddha Nagar, UP, hereinafter called as the first party. And number two, we have X son of Y, resident of 52 Lajpat Nagar, New Delhi, hereinafter called as the second party. These are the two parties to this arbitration deed. Now, the background of this agreement is, which generally begins with the word whereas. Whereas the first and the second party have been carrying on the business of sales and purchase of electrical goods being carried on at shop number 109 at the first floor of GIP Mall, Sector 18 Noida, District Gautam Buddha Nagar, UP, in partnership under the name and style Vijay Electronics since 1st January 2010. This was the business which was being done between the first party and the second party. And they have a long association since 1st January 2010. They were doing the business of sales and purchase of electrical goods. Name of the firm was Vijay Electronics. And this shop was situated at the first floor of GIP Mall in Sector 18 Noida, District Gautam Buddha Nagar. And the second portion to be drafted in this deed is, which also begins with the word whereas, and whereas both the parties have invested equal capital at the beginning of the business. Equal share in capital was invested by both the parties. And whereas both the parties have equal share of profit and loss in the partnership business. As usual, the capital investment was equal by both the parties Hence, they have equal share in profit and losses of the partnership business. This is the background. Now, where the difference has arose, why the need of arbitration arose? You will have to draft it like this, that, and whereas the differences have arisen between the parties, and now it has become impossible to carry on the business under partnership. There's a lot of dispute between the two parties, and they are not able to settle their disputes at their own. So this is to be mentioned here. And whereas the parties aforesaid have agreed to refer the matter hereunder to two arbitrators, namely Mr. Justice A.B., son of C.D., resident of house number 9, Sector 105, Noida, District Gautam Buddha Nagar, UP, retired judge of High Court of Judicature at Allahabad, nominated by the first party. And Mr. Justice E.F., son of G.H., resident of house number 11, Sector 105, Noida, District Gautam Buddha Nagar, UP, retired judge of High Court at Delhi, nominated by the second party for their decision. So see, dear students, here in this illustration, first party has appointed one arbitrator who is retired judge of High Court of Judicature at Allahabad, and second judge who is also a retired judge from High Court of Delhi is appointed and nominated as arbitrator by the second party. Now we have even number of arbitrators before us. It has to be made odd. Now with this background, the operative part of the deed starts, and it has to begin like this, has to be drafted like this, that now this deed of arbitration witnesses as under. Now these are the terms and conditions which parties have mutually agreed. Point number 1, that the profit and loss account of the partnership business shall be prepared under the supervision of aforesaid arbitrators. You see, there is a dispute between the parties regarding distribution of profit and losses, and accounts are to be prepared. So these accounts shall be prepared under the supervision of the arbitrators. Good. Point number 2, that the liabilities to pay the dues of the creditors by the parties shall be settled by the arbitrators on settlement of the account. Of course, firm has to pay the dues of creditors in the market also. So this liability to pay the creditors on behalf of the firm shall be settled by the arbitrators on settlement of accounts. Third, that the arbitrators shall decide the date on which the partnership firm shall be deemed to be dissolved. Since firm is going into losses, parties are not willing to continue with the business, firm has to be dissolved. And it can be dissolved by mutual consent of the parties, and they have delegated their consent to the arbitrators in the form of para number 3, that the arbitrators shall decide the date on which partnership firm shall be deemed to be dissolved. And dear students, the time of giving award by the arbitrators is to be fixed initially by the parties, so that the matter may not be delayed and award is given by the arbitrators within the stipulated time. So this paragraph is to be drafted like para number 4, that the arbitrators shall decide the matter within 4 months. But in case the matter is not decided within 4 months, the time to make the award shall be extended by mutual consent of the parties. Initial period given to the arbitrators is 4 months, that they should give their award within 4 months. But if the matter cannot be decided in 4 months, then time to make the award shall be extended, again with the mutual consent of the parties. Now I told you that there are two parties in this deed, and each party has appointed one arbitrator. They are in even number. How to make it odd? You will have to draft one paragraph on this issue also, like para number 5. That the arbitrators are entitled to appoint an presiding arbitrator when they require during the period in which they are required to make the arbitration award. After appointment of these two arbitrators, parties have authorized these two arbitrators to appoint a third arbitrator who takes the position of an umpire under the old act and the position of presiding arbitrator in the new Arbitration and Conciliation Act. So with the appointment of this presiding arbitrator, the total number of arbitrators is now 3, which is odd number required by law. Now sometimes there is a difference of opinion between the arbitrators also. You will have to take care of this aspect also and draft one paragraph in the deed, like para number 6, that if the arbitrators agree among themselves on the matter of dispute, then their award shall be final. If there is a unanimous decision of two initially appointed arbitrators, there is no difference of opinion, so award given by original two arbitrators shall be final. But if they differ on a particular matter, then presiding arbitrator, who has the position of an umpire, he shall decide the matter, and award given by that umpire shall be binding on the parties. If two arbitrators are deciding the matter unanimously, there is no problem. But if they are divided 1:1, then the casting vote is that of presiding arbitrator. His opinion shall prevail. Award given by the umpire, award given by the presiding arbitrator shall be final and binding on the parties. Because the original arbitrators are already divided 1:1. Hence, the vote of decision of the presiding arbitrator becomes important. Now, when arbitrators are going to sit, when they are going to hold the meeting, they will have to inform the parties. So this fact is also to be drafted in one of the paragraphs in this deed, like para number 7. The arbitrators shall issue notice to the parties for appearance to clear the position of dispute and produce evidences which they think proper. So it is the duty of the arbitrator to issue notices to the parties, informing them the date of appearance and making their submissions on the position of the dispute. And arbitrators are authorized to take evidence of the parties whenever they think proper. And dear students, the strict rules of Indian Evidence Act are not applicable so far as arbitration proceedings are concerned. And if after notice, parties do not appear before the arbitrator, or one of the party appears and other party does not appear, then arbitrators are authorized to decide the matter ex parte. This is also to be drafted by you, like I have added in para 7, that the arbitrators shall issue notice to the parties for appearance to clear the position of the dispute and produce evidences which they think proper. But if the parties do not appear, the arbitrators shall decide the matter ex parte. They are not bound to wait. If once the notice of the date fixed is served upon the parties, and if one of the party or both the parties do not appear, then arbitrators will decide the matter ex parte in the absence of the parties also. Now, dear students, you have drafted this deed. Deed is binding on the parties, and parties always include their legal representatives, their assignees and heirs also. So even if the parties die during the pendency of arbitration proceedings, it makes no difference. The award given by the arbitrators shall be binding on the legal representatives of the parties. So this factum is also to be drafted in one of the paragraphs, like para number 8, that this deed of agreement shall be binding on the legal representatives, assignee, and heirs of the parties in case of death of either party. Dear students, this is a case where profit and loss is to be calculated. Initial investment is to be seen. How much is to be paid to the creditors is to be calculated. How much is to be recovered from third parties is also to be taken into account. So for this work, an accountant may be needed, because arbitrators themselves may not be in a position to make detailed accounts of this firm. So arbitrators may need the help of an accountant also. So parties should authorize the arbitrators to appoint an accountant if needed. So this factum is also to be drafted in one of the paragraphs, like para number 9. The arbitrators may, if they deem it necessary, appoint an accountant for finalization of the accounts, and shall fix the remuneration of the accountant, which shall be included in the cost of the arbitration fees. Yes, arbitrators have been authorized to appoint an accountant, and arbitrators shall fix the remuneration of the accountant also. It may be lump sum payment, or it may be monthly payment, depends on the nature of the work and depends on the discretion of the arbitrators. How do they appoint an accountant, and what will be the terms and conditions on the basis of which the accountant is appointed. But the salary or the remuneration which is being paid to the accountant shall be added in the cost of arbitration fee, and this fee is to be paid by the parties. Now suppose the arbitrators have given an award and a sum of money is due towards any of the parties. Then what to do in those circumstances? You will have to imagine and draft solution to this problem also, like para 10, that on the arbitration award, if any sum is due towards any of the parties, then the party in whose favor the award is given may apply to the court for a decree upon the award and its extension thereof. So, award is given in favor of one party against the other party. So, party in whose favor the award is given may apply to the court, civil court, for a decree upon the award and its execution also. Dear students, the parties and the arbitration agreement has to be drafted under the provisions of Arbitration and Conciliation Act of 1996. This is also to be mentioned in one of the paragraphs, like para number 11, that except the matter provided in this agreement, the provisions of Arbitration and Conciliation Act 1996 shall apply to the present arbitration. Yes, you will have to accept that provisions of Arbitration and Conciliation Act 1996 shall apply to the present arbitration, present matter which is being referred to arbitrators. And dear students, so far as the cost of reference expenses of this arbitration is concerned, it is always the discretion of the arbitrators to fix the cost of deciding this disputed matter or cost of this reference. So this you will have to keep in mind while drafting this deed of arbitration. You will have to draft one paragraph like para 12, that it shall be the discretion of the arbitrators to fix the cost of this reference. It is always the discretion of the arbitrators to fix the cost of the reference. Now finally, dear students, you are to mention this factum also in this deed, that the above named parties do hereby agree to all the terms and conditions stated above without any duress, caution, or undue influence, and after fully understanding the terms of this deed of arbitration, and they bind themselves, their respective heirs, assignees, and legal representatives, and hereby put their hands on this first day of January 2017 in the presence of two witnesses. So this factum is to be drafted that terms and conditions agreed in this deed are without any duress, caution, or undue influence. You know, the award can be set aside on this ground that the agreement between the parties was not with the free consent of the parties, rather it was under duress, or one of the party one of the parties' consent was not free, and his consent was obtained under caution or undue influence. So care has to be taken that this fact must be drafted by you while drafting arbitration deed. Now both the parties will put their signatures on this deed. First of all, signature of the first party. Our first party is A, son of B, resident of flat number 906, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, UP. First party will sign this deed. And of course, the second party, X, son of Y, resident of 52 Lajpat Nagar, New Delhi, is our second party. And they will also sign this deed. And this deed is to be signed in the presence of two witnesses. Witness number 1 will sign. Our witness number 1 is C, son of D, resident of flat number 510, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, UP. He will sign this deed. And witness number 2 will also sign this deed. Our witness number 2 is E, son of F, flat number 511, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar. So dear students, this is how a deed of arbitration is to be drafted. If I may summarize the legal position of this drafting, basically the free consent of parties is needed to refer the matter to the arbitrators. If the consent of the parties or one of the parties is not free, then award given by the arbitrators is liable to be set aside by the competent civil court. Then, in our illustration, there were two parties. Each party had nominated or appointed one arbitrator each. So their number has gone even. It has to be made odd. And authority is given in this deed that two appointed arbitrators shall appoint a third arbitrator known as presiding arbitrator, and his opinion prevails in case of division of opinion between the two originally appointed arbitrators. But if the originally appointed arbitrators, they have given a unanimous award, unanimous judgment, then there is no role of presiding arbitrator or the umpire. But if there is a difference of opinion between the two appointed arbitrators, then role of umpire, the role of presiding arbitrator becomes important, because he, together with even number, makes the number of arbitrators as odd, and whatever opinion is given by the presiding arbitrator, his opinion becomes final, because two arbitrators are already divided 1:1. And you will have to give authority to the arbitrators to appoint a presiding arbitrator at their discretion. And dear students, care must be taken while drafting this deed that who will pay the cost of this arbitration. The cost is to be paid by the parties, but who will decide the cost? Cost will be decided by the arbitrators themselves. And if some clerk, stenographer, or accountant is appointed for the purposes of carrying into effect the arbitration proceedings, then remuneration of that clerk, stenographer, or accountant, his fees, his remuneration, his salary is to be added in the cost of arbitration, which is to be paid by both the parties. And lastly, the signature of both the parties are very essential, because arbitration agreement cannot be oral. It has to be in writing. So both the parties will put their signatures on this arbitration deed, and two witnesses will also sign this arbitration deed. You will mention the place where this deed was drafted, date on which this deed was signed, and who drafted it. Normally, an advocate is involved in drafting the deed of arbitration. So you will have to mention that this deed was drafted by ABC advocate at Noida. So dear students, thank you very much. We have now learned how to draft a deed of arbitration. Yesterday, in the last lecture, we had learned how to draft a deed of reference. Today, we have learned how to draft a deed of arbitration. So thank you very much.